First of all, good morning or good evening to some. I would like to start thanking all of you for attending today's presentations, and who knows, maybe by the end of today's presentations you're thanking us for the information that we're giving you. So we all know how important it is to understand the basic concepts of your first years in law school. They're really relevant and really important. So you might be asking what we'll be talking about, and let me make your dreams come true and introducing you to the principle of good faith. Good faith in civil law and common law systems will be what we will be studying today. With our presentation today, our group will take you back to its origins, where it originated in the Roman law system, and will take you in a case scenario for the civil law and the common law system respectively. So by the end of the day, you are as knowledgeable as we are when we were making this presentation, if you're not falling asleep by minute 5. Now, let's start with something simple. The definition of good faith that we have right now. So everyone's on the same page and we're not having like mixed ideas on what we're really talking about. So for starters, good faith as defined by Cornell Law School is a term that generally describes honest dealing. Depending on the exact setting, good faith may require an honest belief of purpose, a faithful performance of duties, observance of the fair dealing standards, or an absence of fraudulent intent. So to translate to a more understandable language, to more understandable and simple English, good faith means that you walk into a contract with no ill intent. You have no harm intended to your opposing party. That's as basic as we can make this term good faith. Now that we know the principle of good faith, we can look back to what I believe is the favorite subject of everyone right now, Roman law system, because that's where the first recorded idea and principle of good faith is recorded, under the idea of fades, which literally meant good faith in Latin, fell under the category of obligations inside the contractual law system in Rome. So good faith was developed into, and pardon my Latin, it's kind of rusty, I know, is inducia bonae fidei, or actions of good faith. I feel like I'm pronouncing that right. So let's continue. In order not to bore you all to death or make you tune out because I just mentioned Roman law system, let me summarize this for you in a really neat package. In a court's case, second phase, the iunex, or the judge of back then, could base a decision on whether the parties had displayed good faith or not. This was pretty much an essential part of contract law in the Roman law system. And this definition and these ideas were the ones that led to good faith being developed later on in the civil law and common law system as we know them today. Now I'm let you, my fellow classmates and my fellow teammates, to continue explaining for today.
In order to make sense of how this concept applies to the law, we must first understand what a legal system is and how the main systems differ from each other. Legal system refers to the way law is interpreted, enforced, and the procedures it takes to reach an end. Being the second most popular system in the world, common law began during the Middle Ages in England as a set of unwritten rules to remedy legal conflicts. Nowadays, common law systems base their decisions on prior cases rather than legislative enactments. Judges rely on their predecessors' decisions rather than on abstract codes or texts for them to interpret. Under a common law system, disputes are settled through an exchange of arguments and evidence. Both parties present their case before the judge. The judge then evaluates the evidence, applies the appropriate law, and takes as reference previous cases. And then the judge judges in favor of one of the parties.
Good faith and fair dealing is a general presumption by which parties to a contract are expected to deal with each other honestly and fairly, so as not to destroy the right of the other party to enjoy the benefits of the contract. The core principles of common law, as we previously highlighted to be based on case law, means that the concept of good faith exists, but is not as clearly defined as in the civil legal system. The historical reluctance of the courts to imply a general duty of good faith is due in part to concerns that doing so would undermine contractual certainty. Instead, the English courts have, as Lord Justice Bingham put it, preferred to develop piecemeal solutions in response to demonstrated problems of unfairness. Before I lose all of your span of attention, let me rephrase this. There is no generally accepted definition of the concept of good faith under English law, but The general idea behind good faith has been conveyed in previous rulings through expressions such as playing fair, coming clean, or putting one's card face upwards on the table. So we could argue that, indirectly, good faith has been recognized as an essential principle for fair and open dealing. Okay, now that we're done with the dull part of the lesson, let me exemplify what I have explained through the analysis of a case. In this court proceeding, SVP ordered 47 photographic transparencies from the Interphoto Picture Library, IPL. On the delivery note was a clause stating that transparency should be returned with 14 days of delivery. If they were not returned, a holding fee of £5 per transparency per day would be charged. SVP returned the transparencies 4 weeks later and received a bill for over £3,700. SVP argued that the fee was 5 times higher than any other company, and since this was the first time they had entered a contract with IPL, that they should have made it explicitly clear that there was such an enormous fee. When there is such an inconvenient clause, the party imposing it must show that they have taken reasonable steps to bring the clause to the other party's attention. IPL had failed to do this, and they could therefore only recover fees assessed on a quantum merit basis, meaning they were only paid an amount corresponding to the services they had provided for, and not the full exorbitant fees of £3,700. The concept of good faith was applied in this case.
As previously said, common law relies on past cases. By contrast, civil law systems place much less emphasis on the precedent than they do on the codification of the law. They rely on written statutes and other legal codes that are constantly being updated, which establish legal procedures and what can and cannot be brought before a court. In a civil law system, a judge merely establishes the facts of the case and applies the remedies found in the codified law, and because of this results in lawmakers, scholars, and legal experts to have much more influence over the administration than the judges on it.
Hi, so this leads us to the modern civil law family, of which good faith is a founding pillar. However, like they always seem to do, experts disagree as to the meaning of this concept. To illustrate the scope of this lack of uniformity, I'll be using 3 example definitions. The first one by Peden, he described good faith as an implied obligation. The second one by Roland, he labeled good faith as a behavioral norm. And thirdly, in a survey conducted by Hesselink, the following descriptions were collected: norm, maxim, source of unwritten law, and duty. I think it is by now evident that legal scholars pretty much disagree on everything. So I'll simplify this by highlighting 2 of the most common senses: the subjective one and the objective one. In Quebec law, the new code gave a central role to good faith. There were numerous applications of the term in the particular provisions of the code. For example, in Article 2088, where it says that there was a duty for employees and agents to act faithfully and honestly. In total, good faith was employed 86 times. If we're to look at the other side of the analysis, the absence of good faith signals unconscionable behavior, which in French is characterized as blâmable, choquant, déraisonnable, or to translate for my non-French speaking friends, to be blamed, shocking, and unreasonable. For instance, Pinot defined that one should not profit from the inexperience or vulnerability of other persons to impose on them draconian terms and therefore squeeze out advantages which do not correspond to what one gives to them. So before Spanish people start asking me en Latin, por favor, let me reword this in a simpler way. You might ask me, what do we agree on then? Because this is getting very confusing. Well, there is a consensus among scholars, at least one, that the law of contract should guarantee that contractual agreements follow the requirements of good faith. Some stipulations of good faith that have been established include duties of loyalty or cooperation in the law of mandate. As I can bet that by now, I've pretty much lost half of you. Let me apply the notion of good faith to a real life case so that maybe some of you can walk out of here remembering something. This particular case took place at OLG Caen's Provincial Court of Appeal, with a decision being issued on the 21st May 1996. And Before I get screamed at by everyone, please note that German case citations do not identify parties to proceedings, so I cannot say X versus Y. Sorry. To make things simple, the seller sold a used car to the buyer, both parties being car dealers. The document showed that the car was first licensed in 1992 and the mileage on the odometer was low. The sales contract included the exclusion of any warranty. The buyer later sold the car to a customer who discovered that the car had been first licensed in 1990 and that the actual mileage of the odometer was much higher. The buyer paid damages to his customer and demanded that the same amount as damages from the seller. The appellate court held that the buyer could claim damages. The buyer's damages caused by its liability to its customer could be claimed under Article 74 of the CISG because such damages are foreseeable if goods are sold to a dealer who intends to resell them. Even though the buyer could have detected the car's defects, the seller could not use Article 35 of the CISG as a defense since the seller knew the actual age of the car and had therefore acted fraudulently. In the articles listed as having contributed to the court's decision, there is one which is of particular interest for us. Article 7A33, the applications of good faith standards. You might have also noticed that I've repeated various times the abbreviation CISG. So for those of you who don't know, it stands for the United Nations Convention on Contracts for the Sale of International Goods. And what is most interesting is that their database of records indicate that the term good faith has already been employed 10,246 times in court rulings, hence demonstrating the significance of good faith in the current application of the law.
The concept of good faith, as mentioned earlier by Juan Manuel, can be traced back all the way to the Roman times, when it fell under the category of obligations. Why is this important to remember? Because this obligation is still representative of how civil law and common law systems implement the concept of good faith nowadays. The role of principle of good faith, in essence, is uniform for both legal systems, and its purpose is to enforce honest dealing and to abolish ill intent between parties, representatives, and institutions. So now you might ask, if the role of the principle of good faith in common law systems and civil law systems is the same, then what's the distinction? Simple. The way in which it is conveyed. As we have seen before, there are two meanings for good faith in civil law systems. First is the subjective meaning, which refers to the justifiable ignorance of some legal information. This logic has been developed in the economic analysis of tort and civil liability law. So the way that civil law systems implement good faith in these instances is by trusting that parties are taking the proper precautions in order to avoid the risk of misinterpretation of relevant facts, as we have seen in the case of Hadley Byrne and Heller and Partners, 1964, between the plaintiff and the defendant. On the other hand, the objective meaning of good faith in civil law systems precludes the concept of proportionism. This means that petitioners and parties should act in good faith by intentionally avoiding to take advantage of a known asymmetry within a contractual relationship. Unlike in the subjective meaning, this applies to situations in which there is deliberate ill intent. Thus why the objective meaning of good faith in some civil law systems has been implemented in codes and statutes, as it has in the case of Quebec law. Bringing us to what really distinguishes the implementation of good faith in common law and civil law systems. On the one hand, in civil law, good faith is not just exercised by a customary way, but it can also be formally enforced by others in the form of codes and statutes, as opposed to how good faith is implemented in common law systems, which is exercised mainly by parties, lawyers, and judges through customary practice. And that's the difference.